Asylum. Let's talk about asylum because we have to. 1.6 million cases pending with both USCIS and Immigration Court. In this video, we are going to talk about asylum in detail, okay? And why it is important for you to get it right the first time around. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the globe because we're dealing with complex U.S. immigration laws cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. We have TikTok, Instagram, Facebook page, Facebook group. Well, let's get right into the subject, asylum, okay? First of all, the reason I'm talking about asylum today in details, it's because I want you to really get it. And I want you to really, if you apply late, to kind of get a sense of how you can pretty much argue your first, the 1 year, the deadline exception, right? For the first time in court, how are you going to deal with it or argue about it? Because we have an upcoming trial on April 27, and eventually the case was referred to court because, again, application was late, okay? So, asylum, based on what? Based on fear of persecution, well-founded fear of persecution, basically either in the past, something that happened in the past, or the presumption that it's gonna produce itself in the future. It's basically the story has to be based on race, religion, nationality, membership in a particular social group, and political opinion. And the way you're really arguing is that you have been persecuted either in the past or you're going to get persecuted in the future. And if those acts of persecution are coming from private entities, and you're trying to argue that the government cannot control those people, okay? So that's asylum, but you have to make your case, right? So we have three types, right? Affirmative asylum, defensive asylum, and we have people who are in expedited removal proceedings. Those are people who eventually get apprehended at the border and get into expedited removal proceedings. I'm going to talk about it too, okay? Affirmative asylum, basically you're here in the U.S. and within 1 year you apply for asylum, or you apply late, but you're physically present in the U.S. and you file your application for asylum with USCIS. That's what we call affirmative asylum. And most of the time, some people miss the deadline. When they miss the deadline, what's going to happen is when you go to USCIS and you do not have strong argument about deadline exception, the 1 year deadline exception, then your case gets referred to court. That's when we go to the second point is defensive asylum. Now you're trying to defend your asylum in court. And when you're defending your asylum in court and you have first of all, the fact that you did not apply on time, you have to actually now convince the judge now that what is the reason, right, as to why you did not apply for asylum within 1 year. There's only two ways you can convince, one or the other or both, right? Extraordinary circumstances, something beyond your control happened, either to you or to your representative, or to an immediate family member, which is spouse, parent, or child. That's it, right? So extraordinary circumstances, we have the regulation has already told us what can constitute extraordinary circumstances. It's something, for example, death in a family, somebody died. serious illness, something serious. When we talk about serious illness, it's not just something that you had to go to the hospital, come back, something so serious that prevented you from applying for asylum within that 1 year deadline rule, right? So now you want to argue about the exception. Incapacity, okay? And the list goes on, but those three things are really major. And if you have something that happened, like, for example, somebody died, and the regulation says that when you're arguing that the reason why you're applying late is because somebody died, either it's a immediate family member or your representative, somebody who was supposed to file for you. So the regulation goes on and says that, well, it has to be something that you did not contribute to it based on your inaction or action. Let's say somebody died because of your negligence. You were so negligent, or your negligence, that's why the person died. Well, it's not gonna go, you're not gonna make the point, because it's gonna be like, well, it's because of you that this person died, because of your negligence. It has to be something that has nothing to do with your action or your inaction, okay? Somebody died because they were sick, and that has nothing to do with you. It's just that they were sick and they died pretty much within that time frame, and you couldn't, because you had to deal with funerals and stuff like that. And that situation really is related to you not being able to file for asylum within 1 year. That's why now you're claiming that exception. You see how it's going to work? So that's for extraordinary circumstances. Extraordinary circumstances. And then if you cannot go with extraordinary circumstances, then change circumstances. It can be in your country of origin, or something change here fundamentally in the law, or something change based on whatever that's going on around you, or based on yourself, something drastically change, and that thing really prevented you from applying for asylum within that 1 year deadline, okay? But for this one, change circumstances, if something changed, then they ask for reasonable time, okay? Let's say something happened, let's go with change country conditions, okay? Maybe there's something, they change the political system, or you guys have a new president, okay? Let's say they elected a new president on January 1st, and you wait until July 1st to apply for asylum. That's not within a reasonable time from the change of that circumstance, okay? It has to be within a reasonable time you apply for asylum. One thing I want to add about this change of circumstances is that here in the Fourth Circuit, and even in the Second Circuit, I don't know about some other circuit, but I've argued in Second Circuit and here in the Fourth Circuit, well, we have a case where we can use, basically, even when your case of asylum is still pending with USCIS or with immigration court, and something drastically change, even after, right, we can always go back and claim that change of circumstances, okay? For example, you apply for asylum late, while case get referred to immigration court. And when the case gets referred to immigration court, and well, you don't have an exception, and now suddenly something changed in your circumstances, or the person you were fearing back home just became aware of your situation here, and they really clearly give you some threat that they're going to kill you if you go back home, well, and you have proof of it, well, that's change of circumstances. Even if it happened after, okay, you can go with it and claim that change of circumstances. Let's say, for example, you get sick really after when your case is still pending with USCIS. They discover some disease in your body, or they discover your mental state is not well, depression, stuff like that. Well, you can claim that change of circumstances, okay? And go back and claim it and argue it, even if it happened after the facts, okay? As long as it's related to the fact that you are applying late, materially affected your case, okay? And let's say, for example, you argue the case and then suddenly you lose your case, and the case, you have an order of removal after the facts, and then the change of circumstance happened later. As far as change country circumstances, well, you can reopen your case. Remember, we have a motion to reopen webinar on April 7, 2023, 5 p.m. Eastern Time, where I will really going to go in detail and explaining how you can make a motion to reopen because of change country circumstances, change of country conditions, basically change of circumstances, okay? And then reopen your case. Change condition in the country. That can help you reopen your case even after the deadline, okay? So that's a different subject, but I just wanted to stay with asylum for the purpose of this video. So once you argue either one or both, extraordinary ability, change of circumstances that materially affected your case, then you go to the argument now of the asylum in question, right? So now you have to prove fear of either past persecution or fear of the future persecution, well-founded fear. So let's say, for example, you're in court and then they say, well, you did not meet the burden of past persecution. What are you going to do? Okay? Then you have to claim the fear, well-founded fear of future persecution. The way you claim it, the fear has to be subjective, meaning that your testimony has to have credibility. Then the fear in question has to be objectively reasonable, which means it has to be founded in reality. And at that point on, you can even show pattern of persecution. So if you can show there is pattern of persecution of those type of people in your country, then you don't have to show that you personally going to be singled out, okay? So that's really how you argue your case in court when it comes to the fear of future persecution. And I wanted to touch base again on expedited removal proceedings. Well, expedited removal proceedings basically is usually applied to people at the border. When you get apprehended in detention, they put you in expedited removal proceedings. Then your case gets referred to USCIS if you pass the credible fear of persecution, that test, right? The first test. If you pass it, the case gets referred to USCIS. Then USCIS will, you get apprehended. I have to go back a little bit. You get apprehended, detention, you are totally in expedited removal proceedings. What's going to happen is that USCIS will give you a test, right? Interview for credible fear of persecution. That's the test, the first one. If you pass it, then you go to the second test, the merit test. That's the second interview, the merit test. And that's where you are going to demonstrate your eligibility of asylum, again, based on a well-founded fear of either past persecution or well-founded fear of future persecution. And at that point, if they can't, you don't pass those, you can't convince them, then they're gonna look at eligibility on the withholding of removal and Convention Against Torture, CAT, okay? USCIS is doing it too for those expedited removal proceedings, okay? With this Biden administration, USCIS taking upon withholding of removal as well. So that's about it, right? For asylum. Asylum, you can win it. Really, you can win it if you have arguments and you have proof and there is credibility in your testimony. Try to get it the first time at USCIS. If you cannot, then try to get it the first time in immigration court, because the moment you start going to appeal and the moment you start going to federal court to review the immigration judge decision, that's when the chances are less and less, okay? And that's why it's important to get a sense of what's going on and to get prepared for your interview so that you don't waste the time in immigration court. Remember, 1.6 million cases, okay? You don't want to be in that position. So now about the backlog, what exactly can you do? Well, you have to try, first of all, if your case is pending with USCIS, try expedited request. Expedited request might work. Not guaranteed, but you can try it. The case has been pending for 5 years or more, my friend, try expedited request for humanitarian reasons. Humanitarian reasons, the list goes on. You can talk about country conditions, okay? Country conditions, the way people are living there. Specifically, if you have a family left back home, well, try to make that type of argument. If you have somebody seriously sick, try to make that type of argument. If you have a disabled person, disability, try to make that type of argument. If it doesn't work, try to get your congressman involved. Doesn't work, then go straight to federal court and sue the government for unreasonable delay. The reason we want you to start with other stuff first is basically you're making up you building your case, okay? You building your case so that when you go to federal court, the judge has no option but to order USCIS to interview, to deliver, right? To do their job. 5 years, 6 years, 7 years, that's a long time to wait, okay? So if you need the consultation again, consultation link is in the description box below. Until next time, bye-bye.